Hello, everyone. We'll be starting the webinar in 4 minutes. Thank you for joining in early. We'll start at 12 p.m. Eastern. Thank you. Hello, everyone. We'll be starting the webinar in about a minute's time. Thank you. Hello, everyone. It's 12 p.m. Eastern. We will be starting the webinar now. Thank you so very much for your patience. Today's topic is exploring US work visa alternatives. I'm joined alongside Prashanti Reddy. My name is Vishal Sharma, and I'm your moderator for today's session. Prashanti is an award winning immigration attorney specializing in immigration law with over 25 years of experience. She has been an esteemed member of the American Immigration Lawyers Association and the New York Bar Association, and is currently admitted to the bar in New York. Prashanti is currently also actively involved in advisor slash immigration counsel for Indian consulate in New York and is actively involved in pro bono legal work as well. Being in the industry for over 25 years, Prashanti has received many recognitions from industry bodies and across. Some of them are listed here. One of the most recent ones include Forbes recognizing Prashanti as one of New York City's best immigration lawyers in 2024, amongst other achievements and recognitions. On that note, Prashanti, I'd like to invite you to kick off today's session with immigration updates. And before you start the immigration updates, just a gentle reminder for everyone joining today's session. We will be having a Q&A round by the end of the presentation. We understand that these sessions are incredibly important for those who have questions and need assistance. So please have your questions ready. You can type in your questions throughout the presentation as you have. Our request is to keep your question in one single text and send it over to us. For those joining the session directly through the streaming platform, you can type in the question in chat. And those who are joining us through other social platforms like YouTube, Facebook, or LinkedIn, you will have opportunity to type in your questions under the chat option. So, sorry, comment section. So please do use this opportunity to ask Prashanti questions, and Prashanti will be taking them up by the end of today's presentation. On that note, over to you, Prashanti.
Hello, Vishal. Thank you for that introduction. Let's go right ahead with immigration updates. Let's go to the first slide. We're talking about the September visa bulletin. As you might know, the visa bulletin was just published, and we don't see much change for the month of September. And the reason we don't is because this is the last year month for this fiscal year. October brings again new numbers because the new fiscal year starts, and there'll be about 145, 160,000 numbers reintroduced again next month. So we're hoping for some forward movement. But for this month, we were expecting retrogression. So luckily, the good news is there's no retrogression. It is pretty much no change in all the categories, which means that there are still some green card numbers available, but not many. So they don't want to introduce new people into the system. They think that whatever applications are right now pending will make use of all the green card numbers. They try to finish all the green card numbers every year because the green card numbers don't roll over to the next year. So hopefully they're doing that this month as well. But sometimes we do see that in the middle of the month, there is a new visa bulletin issued where they say unavailable. That is sometimes happens in the month of September. This is when we know that all the numbers have been used up. So September, let's see what actually happened. So for the month of Mexico, for the month of September, F2B Mexico is moved up. This is F2B is family-based category, F2B. Mexico moved up by 3 months. F2B Philippines moved up by 16 days. And F3 Philippines moved up by 5 months. So we see there is some movement in the family-based categories for Philippines and Mexico. Next slide. As I said, no forward movement in employment-based. You see EB1, EB2, EB3, EB5, no forward movement. EB4 is the religious worker category, which is completely unavailable. So there are no green card numbers left for that category. That's why it's unavailable. Next slide. And insights, I think I've already given you some insights. As expected, we saw no forward movement except for that Philippines and Mexico family-based cases. For all the employment-based cases, we saw no forward movement as expected, but at least there was no retrogression, which is good. Next. Just go back to the previous slide. So what to expect for the October visa bulletin? I would say that I'm expecting there'll be some forward movement in some of the family-based categories, especially in F2A, because we've seen good progress in F2A based category even for India. I'm expecting some forward movement for EB3 India, as there has been forward movement in the past few months. EB2 is heavily backlogged, so I don't expect much forward movement in EB2. We might see some forward movement in EB1 India, and of course, um, rest of the world uh, will be current most probably next month as well. So let's wait and see what happens. But since the October new green card numbers are introduced, you will see some forward movement in the coming months of October, November, and December. We also expect that in October, the dates for filing a table will be used in both family as well as employment based categories. So that's a wrap on this September visa bulletin. Let's go to the next update. Next slide. I wanted to give you an update on what's happening with the H-1B cap selection criteria. As you know, now there is the selection criteria for H-1B cap cases. So those cases that are subject to the cap, those cases, in those instances in which you've never filed a H-1 before, you will be subject to the cap. Every year there are 85,000 numbers available for new H-1Bs or cap H-1Bs. And generally, because the applications far outweigh the number available, there is a lottery system to be able to select the 85,000. Before it used to be first come first serve, then they introduced a lottery system. Now they want to remove the lottery system completely and introduce a salary based ranking system. This has already been approved by OMB. It is going to be published soon. Let's see what it entails. So basically, people with higher wages or advanced qualifications would be given first priority. Next. So level 4 to 1, it'll be for level 4 given first priority, then level 3 wage, level 2, level 1, and so forth, so on. Universities will be exempt as before. Maybe beneficiaries who have higher qualifications or maybe some particular jobs will receive priority. We don't know, but I think it will be mostly salary based. Why did they come up with this change? The reason that they have given is that there's duplicate filings, fraud, and they think that favoring high wage positions is a merit based system that they should follow rather than the random system. However, we've seen that there's been no fraud since they started the beneficiary centric lottery system where only one beneficiary can get only one pick. There's been reduction and almost elimination of the fraud. So I guess the only reasoning is that they want to favor only people who are paid higher salaries. Next slide. Who benefits? Those people obviously who are paid higher salaries, maybe bigger companies that are able to afford those higher salaries, they'll most probably be benefited. And those, F1 students, entry level people, level 1 wages, consulting companies, because they usually pay level 2, and that won't be prioritized. It will be level 4. And if everything, I'm presuming level 3 and level 4, will be enough to fill the quota, and level 2 won't even be used. So let's wait and see how that pans out. And of course, recent graduates will have almost zero chance of getting into the cap. What's the status of this law? This law has actually been approved by OMB since we wrote this document. There's a recent update from the White House that they've approved it. So now they're going to publish it very soon. Once they publish it, then there'll be a comment period. Then they'll gather all the comments that they get, and then they will finalize the rule. That's the process, and they expect it to roll out by next cap season. Next slide. So that's the updates that we have. Let's now go into the alternatives for the H-1B cap. What is H-1B? First, let's discuss that very briefly. H-1 is a specialty occupation work visa. Basically, if your job requires a bachelor's degree in a specific field, and if the employee or beneficiary has that kind of degree, then you might qualify for a H-1B visa. And as you have seen, it's employment based, sponsored by employer. And as you've seen, there is a numerical cap, as we just discussed, 65,000 for the regular cap, and US masters cap is an additional 20,000. H-1B is usually for 3 years, and then it can be extended for another 3 years for 6 years. And if you have an I-140 approval, it can be approved, it can be extended beyond that as well for an unlimited period of time. Next. So why is it important to look at the alternatives to a H-1? Because this is a highly selective, competitive selection process. As you saw, 85,000 is the total number available. And generally, about 400,000 applicants. We have about 400,000 applicants. So that's, you have about 25% chance of being selected. So it's good to have, to see if you qualify for any of the alternative work visas. Also, if being on a H-1 is highly restrictive. It leads to a green card, but it's EB2, EB3 mostly, and there's a wait, especially if you're an Indian national or Chinese national. And the policies keep changing, and eligibility criteria keeps changing. Recently, in January, there was an update on, H-1Bs and who qualifies, who doesn't, etc. The LCA wage requirements are very restrictive. Every time you change employment, you have to file an amendment. So it's all a difficult process. It's difficult to be on a H-1B. So an alternative is definitely a good option if you qualify for one. If you don't, then of course H-1B is the only work visa that's available for 80% of people who are working in the US. Next slide. So let's look at the first alternative. That's the L1, intra-company transferee. And L1 is designed for employees of multinational companies. So companies who have offices, say, in the US as well as in India, for example. You could qualify if you are two categories. L1A, which is managerial or executive level. You get an L1A for 7 years, or L1B for employees who have specialized knowledge, and you get that for 5 years. Eligibility is that the person should have worked in that category of L1A or L1B for 1 year in the last 3 years. And you have to prove that they have done that work through documentation. And the documentation is quite burdensome, but you have to submit that. And you also have to show that the US company has a qualifying relationship with the foreign company. The relationship could be that of a parent, a subsidiary, an affiliate, or a branch. So there has to be a qualifying relationship, and the position has to qualify. Next slide. Advantage for the L1 is there's no annual cap. Dual intent is allowed just like a H1. And the biggest advantages is spouses can apply for, are actually automatically work authorized. They don't even have to apply for work authorization. Spouses, L2 spouses can work automatically. The challenges, as I was mentioning, is there's a lot of document requirement, and you have to show strong proof that you qualify. And it is highly scrutinized by USCIS. They look into, they often send RFEs, which are several pages long, and they want detailed documentation. And for some companies, it's not possible to document it because maybe they're mom and pop operations, so documents are not possible. But most companies are able to document it, and if they're able to show that the position actually is that of a manager or executive. This has to again has to be shown through documentation. Next slide. The next category is the O1 visa. This is for extraordinary people with extraordinary abilities in the science, art, education, or in business, or also in sports. This is demonstrated by showing sustained or continuous national or international acclaim. So O1 is requires evidence of to show that you are extraordinary. You have to submit evidence of awards, publications, press release, press coverage, high salary. You have to show that your role is so critical that it is extraordinary. You have to show that you've distinguished yourself within your organization and within the industry on the whole. The good thing is there's no minimum or maximum number of years of experience required. It's completely merit based. But again, the documentary evidence is burdensome. It is difficult to qualify unless you are really extraordinary. But it might be possible to show extraordinary ability in the business, especially if you have your own startup, for example, and you're doing something which is new, something that can benefit the US economy in some way, or the US community in some way. Or it's just something that is so extraordinary because it is new and not done before. That you can show extraordinary ability in that way as well. Next slide. The advantage of O1 is, of course, there's no cap. It can continue to be extended. You can continue to be on O1. And this leads to an EB1 category, green card, which is the best green card category to be in, especially even for rest of the world, but especially if you're Indian national or Chinese national, EB1 is the best category to be in. And if you qualify for O1 extraordinary, you might most probably qualify for EB1 extraordinary category as well. But as I was saying, the challenges is that it's high evidentiary burden. You have to show a strong portfolio of achievements, document everything. May not be suitable for entry level career professionals who don't have notable recognitions. It could be that you're a PhD holder, you've already published several articles, so you might still be eligible for O1 even if you're just starting out, but it again depends on the profession that you're in. Next slide. The next is the TN visa. TN visa is great. There is a list of occupations that qualify for TN. You can find that if you Google it. It's under the USMCA regulations. Formerly, it was under NAFTA. So any professional who is within that job list that is national of Canada or Mexico will qualify for a TN. So the eligibility requirements for a TN is within that job list. For example, some of the occupations are engineers, accountants, management consultants, scientists, and they have qualifications within that. For example, engineers require a bachelor's degree in engineering, etc., etc. And some job requires education and experience as well. So you have to look into that particular document, and if you qualify, then you don't even have to apply for a visa at the US consulate in Canada. You can just go to the port of entry, submit your documentation. The documentation also is pretty simple. We can go to the next slide. Documentation also is pretty simple. You just have to submit a petitioner letter showing how you qualify, your educational credentials and evaluation, and an offer letter, etc. And you should be on your way to the port of entry. There is the advantages, of course, there's no lottery. You don't have to file anything with the USCIS. There is a 3-year and unlimited renewals after that. Lower filing costs because there's no USCIS fee at all. Processing is immediate because you're going to the port of entry and getting processed immediately. The challenge is, of course, it's limited to nationals of Canada and Mexico, and they have to be continue to work in that profession, they cannot change freely to unrelated fields. Next slide. And of course, we have cap exempt H1s. That's an alternative. So if you're working, you can still work within the H1 category and not be subject to the cap if you're working for US higher education institution, non-profit, so like a college or a non-profit entity affiliated to a university. So university or non-profit entity affiliated to a university. In this case, that could be a hospital, the teaching hospital, which is affiliated to a university, could be a good example of a non-profit entity affiliated. Non-profit government research organization, speaks for itself. It's non-profit and it's it's an either non-profit research organization or a government research organization. So if you are working for one of these industries, or you're indirectly working, so say you're working for a consulting company, but your end client is one of these organizations, then you qualify for cap exempt. One thing to be noted for a nonprofit entity affiliated to a university is they want to make sure if you're working in that hospital, for example, that your job is directly related to the affiliation with that university. So say it's a teaching hospital, so you should, for example, be training, if you're working as a nurse, you should be training, um, you know, uh, those recruits from the university, actually training them, because that's maybe the agreement between the nonprofit and the university. That's why there's an affiliation. And the agreement is that the hospital will train or provide practical training to the nurses from that university. Just giving you an example. So the beneficiary's job has to be related to that training of nurses. So that's a big thing to keep in mind. Next slide. Advantages, again, are self-evident. There's no lottery, and it's the same otherwise benefits as a H-1B, same process, same restrictions, so same challenges. You have to continue working for that employer. You have to continue to work for a cap exempt employer. If you switch to cap subject, then again you'll be subject to the lottery, and then you'll have to go through the process. Next slide. There's another type of H-1B also, H-1B1. This is nationals of Chile and Singapore. So obvious advantage because there's a separate cap for them, and this cap doesn't usually get over. It's about 10,000 applications are allowed under this. Requirements are the same. The restriction for this is you have to be a national or citizen of Chile or Singapore, and the rest is the criteria is the same. You have to qualify for specialty occupation, etc. So there's an obvious advantage, as the cap never gets filled for this, but the disadvantage is it's restricted to people from that country. Next. I think, by the way, it's 10,000. It's not 6,800. And yeah, so as I said, it can be renewed, but the challenge is it's only for Chilean and Singapore nationals. Next. Of course, if you belong to any other national other than India or China where there's backlog, you can file for a direct green card. You can file directly for EB2 and EB3 and come in, by filing a perm and then getting an I-140 approved and filing consular processing and then coming in directly on a green card. That's a possibility also. And if you're Indian national, you can do that on EB1 since the dates are not that backlogged. And a lot of people working in multinationals, big companies, they do come in on EB1 green card directly. Next. So the advantages obviously is you get a green card directly. You don't have to worry about a lot of the restrictive regulations. Once you have a permanent resident status, you can work for any employer. You don't have to deal with any lotteries. But of course, the challenge is, as I said, China and India have long processing times because visa numbers are not available. And there is a significant process involved behind the entire thing, and it can still take about 1 to 2 years for processing time itself, because the labor cert, I-140, and then going through NVC does take time. Next. Okay, so I tried to go through the slide as soon as I could so that we'd have time left over for Q&A. So let's start with the Q&A.
Yes, thank you so much for that, Shanti. Uh, we do have a few questions directly on the streaming platform. And a gentle reminder for everyone who's attending today's session, if you have any question, now is the time for you to feed in your question, and Prashanti will be taking them on. Prashanti, first question is from Ravikant Reddy Boma Reddy. Does these levels have any salary brackets?
Yeah, so as I was saying, these levels do have. I think he's talking about is he talking about the new law and the proposed law? Is he
That's what I would assume because this question came in at the early stages.
okay? So please make sure you are specific about your questions, because we don't know. We don't want to be guessing about what you're asking, but I'm presuming you're asking about the H-1B proposed regulation with reference to changing the cap selection criteria. And yes, as I was saying, that they will first look at level 4 salary. Then they will choose all those people that have applied under level 4. Then they will choose level 3. Then they will choose level 2, so on and so forth. So they will go from level 4 to level 1. And if if the cap gets over within the level 4, then they will not even go to level 3 or level 2. So that's how they're going to choose.
All right. Next up is Karthik Buddhireddy. Would like to know about H-1B selection process in 2026, FY 2027.
So as I was just saying, that there might be a new selection process next year, and that might be based on, we don't know exactly, because here, from preliminary reports we hear that it's based on salary. There might be other criteria also. We have to wait and see until the law rule is actually published and finalized, because once it's published, then there'll be comments. Based on the comments, they may or may not make changes, and then finally it'll be published as a rule. So we have to wait and see, but as of now, the indication is that it'll be based on higher salary. So higher your salary, the more likely you are to get picked in the cap.
Okay. There are a few offline questions that we picked, so I'll ask some of those. And in the meantime, if anyone has any other questions, please feed them in. Next question is, my employer is about to file perm for me in a month. I've been told recently that once perm is filed, that would put intent to immigrate on my record, which probably will make it almost impossible for me to get a tourist visa in the US in the future if the green card play doesn't work. Is that true?
So the intent to immigrate comes up not when you're filing perm, but when you have filed your I-140. So when you're filing perm, usually you don't have to answer yes to is there an immigrant petition filed. But once you file that immigrant petition, which is the I-140 actually, not the perm, then you have to answer yes, and that will be a black mark against getting a B2 visa. It may be or may not be, depends on the officer. But they may decide that you have an intent to immigrate because you filed an immigrant petition, and they may not give you a visa. So yes, it's definitely a disadvantage if you have an I-140 pending for applying for a B2 visa. or even an F1 visa for that matter, because both uh, have the requirement that there be no intent to immigrate.
Okay. Next, we have a few more from the screen, so I'll get to it. From Karthik Bodhireddy, why are we seeing more 221G for H-1B while stamping nowadays? Even all documents are clear.
So it could be for various reasons. Of course, there is extreme vetting now under the present administration. There is more vetting, so they are looking at everyone's social media, etc. As you know, they're doing that mostly for F1 students, but they're also doing that for others. So if you work in a particular field, they might need additional security clearance, and they might just send a T221G without any explanation as to, you know, as to why they're doing it, because they usually don't give any reasoning when they're doing uh, extra vetting under security clearance. They might be calling your the actual client or the employer to get more information, and that could be secondary vetting that they're doing. These are all the reasons, some of the reasons why they would put a case in administrative processing, and if there is more vetting, then obviously they're going to do that in more cases, even in cases where which are document complete.
All right. Next question is from Periyasamy Ramamurthy. Hi, any insight you can share on O1? Any recent examples of persons slash startups who may have qualified and any broad criteria as a startup? Example, revenue slash valuation slash IP, etc.
So those are all the things that they look at for a person who is who owns a company and or who is working for a startup and has something innovative to offer. The key thing is, in addition to um, submitting your valuation and your revenues and your trademarks, patents, whatever you might have to show that that itself shows that it's unique. You also have to submit letters from your peers showing that in your space you are an innovator, and the letters that better if they come from people who are already innovators themselves, who are well recognized in the industry, and you have to submit then their information as well to show that they're well recognized. So it's important to do that. Important to, of course, submit all the press that you have in your favor, and sometimes you can actually contact companies to get press because you may not have focused on that before. Any awards that you've received as a young entrepreneur, or there are a lot of business boards that give out awards, so that could be important. Any kind of letter from maybe your government that shows that you're an innovator, or you've helped your community in the country where you're residing right now. So anything that you can think of should be put into the application to make it stronger.
All right. Uh, Next up, we have uh, another question slash comment from Karthik Bodhireddy. Once 221G happened, that administrative process, what will be the next steps? That's actually the question. Yeah.
uh, so once the administrative processing, they say that it goes into administrative processing, then most probably you have to be aware that the employer will be contacted um, to clarify maybe whatever questions they have. They usually send an email to the employer. They may send an email to the beneficiary as well, and they also might send an email to the actual client if there is one, asking a set of questions as to where they'll be working, what is the job description, what is the duration of work, maybe questions about the employer as to how many people they have working on that project right now. So usually it's a standard set of questions, and these are the questions that they usually ask. Once they've gathered the responses to all those questions, that could take 6 months, it could take 3 months, it could take 1 month. Sometimes if it goes into security check, it could take even a year or more. They will respond even either with notification saying that they've rejected your visa or asking you to come in with your passport to get your visa stamped. So those are the two likely outcomes. Um, and if you're not getting a response even after a year, then I would suggest you go for a mandamus petition. That is, you're filing a litigation in court here in the US asking for the consulate to litigate your case, asking for the consulate to process your case within a timely manner. So those are the likely outcomes, and that's the process.
Okay. Uh, yeah, then there are a few comments here, uh, and a few engagement, which is nice to see. Um, we will keep the session on for a few more minutes. So if any of you have any other questions, feel free to drop in either on chat or comment section. Prashanti, I'm going back to some online questions. I can pull in one more for you. Uh, Current employer, a new employer B. I got my H-1B transfer approval with B 3 weeks back. If my end date is A is August 15th and my start date with B, I would say employer B is August 18th, will this cause any issue for having 2 days gap? Please let me know.
Ah, no, it shouldn't. I don't know why USCIS does that, but they often will give the approval from the date that they actually approve the case. They should be giving it from the date that you've asked for on the form. They don't always do that, but I have not seen any issue with that in the past, so I wouldn't worry about it. As long as you have filed before the expiry, or of your previous, or while you are still in status, um, you should be fine.
All right. Another one from Karthik Bodhireddy on our stream. What will happen if we miss the recruitment resume for filing per?
If we miss the recruitment resume for filing perm, what does he? What do they? What does Karthik mean by recruitment resume? Karthik, can you expand on that?
I would assume it's just a resume.
Well, we don't need a resume when we are filing for a green card, but resumes are sent by applicants who are responding to the advertisement that that the employer has placed. And if you miss those resumes, then you may not be able to. If they're not qualified, then you can justify it. But if they qualify, and if Labor Department comes to know, then you're in trouble because you might be removed from the perm system completely. Your employer, or blacklisted because you have misrepresented facts. You might have to go through supervised recruitment for all the cases you filed moving forward. So it's not a good idea to misrepresent anything. At the same time, you can justify it, stating that the error was not material because the person didn't qualify anyway. If that's what the question was.
Yeah, Karthik commented seems to understand that. Prashanti, any other closing remarks for today's session?
I think now that the updates, I hope were useful. And the alternatives, the H1, it's always useful to know what you have, what alternatives you have. I know many of you may not qualify, but it's good to know that you do have some alternatives, especially for an L1. I think a lot of people qualify for an L1 and they don't just realize, they don't realize it. But it does involve leaving the country. If you've not worked for your parent company before or the foreign company before, it might involve investing a year abroad, and then coming back after that so that you'll be eligible for L1 and then EB1. So it might be worth it, something to consider, especially because EB2 and EB3 are so backlogged.
Well noted. We do have another one, another question from Ravikant Reddy Omareddy. Um, my H-1B I-797A is valid one more year only. Now I got 221G. They mailed both client and employer. Both replied appropriately. So if they didn't respond within 1 year, will it be a void?
Yeah, because unfortunately, your approval, they can only grant the visa until the duration of your approval. So if your approval is expiring, then there is no purpose. They will not grant the visa even if the at that time you don't have a valid approval. So maybe you are a good case for uh, like a mandamus application in court, if they don't respond in 6 months. Hopefully they will.
Noted. If there are no further questions, we can call it a wrap for today's session. For those who have joined in, as a token of appreciation, as we always do, we are giving away an early bird complimentary session. All you need to do is drop in your email address in the chat or comment section, or if you prefer to do it through direct messages or email, you can do so as well. And one of our team members will reach out to you to schedule the early bird complimentary session. Before we wrap up, as it's a norm, we keep getting questions, so I'll go back to the chat here. So there's another one from Karthik Reddy. Let's say X provide offer letter with date June 1st, and the person went to the CBP office before 10 days and done with stamping but didn't travel, and he wants to travel now with dependent. What's the solution?
Let's say X provide offer letter. Who is X? Uh,
I'm assuming ex employer.
Ex employer provides an offer letter uh, with date June 1st, and the person went to CBP office. Okay, so basically they're saying if the employer provides an offer letter um, 10 days before the June 1st, and the person went to CBP office before 10 days and done with stamping, but he didn't travel. If you don't travel within the validity of your visa, then you have a problem, obviously, if that's the question you're asking. You will not be able to, even if your visa is stamped, you will not be able to travel.
All right. So hope that answers. Yeah. On that note, we can end today's session. But for some of our loyal followers, you would know we are doing this as part of our monthly webinar session. So the next webinar date, time, and topic will be announced soon. If you have any suggestions, if you want us to speak on a particular topic, please do let us know. And for those who are following our social media channels, you would also know that Prashanti is answering questions on a weekly basis as well through her video series called Ask Prashanti. So there are quite a few ways for you to reach out to Prashanti and get all the help that you need and you're looking for. We will look forward to seeing you in the next one. Prashanti, any final thoughts before we wrap up?
I think I'm good. Thank you all for joining, and do post those questions so that I can answer them on my Ask Prashanti video series.
Fantastic. Thank you so much, Prashanti, for your time today. I will leave this stream open for another minute in case any of you are interested in applying for the early bird complimentary session. But Prashanti, thank you once again.
Thank you. Bye bye.
We wrap today's session and we look forward to seeing you in the next one. Thank you.